Hey, it's Steve Riley. Welcome to this episode of Great Practice, Great Life. Sometimes the practice of law, being in a law firm, just working in our industry can be very, very stressful, sometimes abusive, bad cases, bad clients, bad judges, bad opposing counsel. It can be toxic and really emotionally distressful, just stressful, just straight up stressful. So today we're bringing a national expert, Dr. Day, to help you figure out ways that you can deal with the stress and sometimes the trauma of the practice. So with that, Dr. Day, welcome to the show.
Well, thank you, and thank you for having me today.
Well, it's great to have you here. I know that you're flying around the country, going to different judicial conferences, talking about everything from childhood development and cases to consulting on cases, especially in some of the complex family law cases that you've done. You've done presentations for the AAML, and you're a really sought after speaker, and you're a very unique speaker. Your expertise is very, very, very tight in the legal industry. So I really appreciate you taking the time to be here today.
Well, thank you for having me.
Could you tell a little bit about your practice, and the type of cases you work on and the type of people that you serve?
Oh, absolutely, and thank you for asking. Our business is Psychological Affiliates. Our primary office is in Orlando. Right outside in Winter Park is actually our office, and then we have an office in West Palm Beach. We have 8 associates here, and we cover all sorts of forensic cases, from criminal to dependency. We do civil litigation and family law cases. We have a support team for our psychologists to help us to be efficient. We also travel, so we are able to meet the needs of most kinds of clients who come to see us.
I always try to argue between practicing in a state of burnout is not the best place for you to be, and it's not the best place for your clients to be. Really trying to practice in a position of peak performance, which is a strategy, more or less, and beginning with what you said, sleep hygiene, nutrition, and exercise. So talk to me more about this.
So, when we talk about our routines, most people give up their routines when they're under stress. So, you have to be that's that mindfulness. Okay, I'm getting ready to go into a trial mode. I've got a lot of prep that I need to do. Make sure your schedule allows for that in the normal course of your practice, not cramming 3 days before a 2-day hearing. That cramming is what we used to do in college and graduate school, because we didn't know better. We know better now. So it's about being organized, having support staff. I always feel bad when a solo practitioner or a small firm doesn't have that support. So they take that on for a 12 or 14-hour day before trial and then try to go to an 8-hour trial. Trial work is not the same as in-office work. You have that adrenaline rush, but again, you only get so much of it. So by the end, after lunch, you're going to feel yourself wind down very quickly, and your mind is not going to be as clear. So the 3 basics are sleep, eat, and exercise. Then we throw in something else. Do not drink alcohol during a trial prep or trial. Alcohol tends to be a coping mechanism that we use to calm down and relax. It's not good. It actually has a counter effect on us, and we're less effective if we're drinking during a trial, even if we think it's good for us so we can go to sleep. Actually, the studies say drinking alcohol or wine before going to bed actually is disruptive to your sleep. You'll wake up more, and your quality of sleep is poor.
As a lawyer, I knew I was going to get punched every now and then. Like I knew I was going to get a hit. And I did develop some battle scars and some resilience. However, sometimes the team that I employed, even though I tried to warn them, were not emotionally prepared for some of the things that they would have to either see or deal with in the practice. And then when it happened, or when things happened, they didn't have the coping skills and mechanisms. So let's assume somebody's listening to that, or if there's a lawyer or a team leader who's listening to this, how do they help either protect or mediate when a team member suffers a distressing situation in the practice?
So I think, first of all, we can remediate things like that by doing appropriate training. So the person who's answering the phone needs to be trained on how to respond to that client who calls up in distress. So there are two types. Again, it's distress. And then the other one who's angry, that angry client can be just as difficult to deal with as a distress. So we have to give tools to our staff so they can intervene to the best of their ability without taking it on. And it goes back to those boundaries that I was talking about. I'm here to listen to you, but I'm not here if you're going to be disrespectful for me. And learning where that line is and being assertive. Assertive is different than being passive, and it's different than being aggressive in response. So we have to teach our staff to be assertive. That's stating your needs and your boundaries while asking for your need to be respected. So while I hear you, please talk to me in an appropriate tone of voice. Or it sounds like you're in a lot of distress. I'm here to help you. Can you answer a few questions for me? So recognizing that person's in distress and giving your staff permission to say, I'm going to put you on hold so I can get somebody who can help you better than I can. So again, giving them the skills and permission to know what their boundaries and limits are and to be able to reach out for a more superior staff who may have more experience to work with those things. It's validating your staff that they don't have to be abused by our clients, whether it's the distressed client or the angry client. We don't require them to stay on the phone and be berated or told negative things or yelled at. Not acceptable. So giving our staff permission to say no is so important as a coping mechanism. Because often we don't do that and we expect them to stay on that client with that client. What the staff needs to be thinking about is giving feedback to the partners or higher ups that this isn't a client that should be coming in the office and feeling comfortable to say that. I can't work with somebody who treats me like that as a client. That client is going to be disruptive to the office. What can we do differently with that client? So from a mental health standpoint, we know that people that are coming into a law firm are in distress. They're not at their best. So we try to give them grace, but grace only goes so far when they become abusive to us. So when your associates or your support team says, I can't manage that, don't say, yes, you can. Say, how can we help you? And it may be, I have to change my work position. And I've experienced that in my practice. We have a high stress practice, and people come in and take a job, but it's not the right fit for them. So be ready to move somebody. If they're a valuable employee, but that's not their niche, find another niche for them. But you have to be open as an employer to hear that and be willing to make those adjustments. Make sure that they're being heard. So when a difficult situation happens that they've experienced, make sure they have some safe space to come in and talk about that and to clear their head. Don't assume they can just brush it off. Not everybody is resilient. So if we think about that resiliency and the environment that they've already come from, they may have low resiliency. So recognizing we have to be able to give permission to have that safe time away from whatever that event was. Because we don't want our valued employees leaving. And that's the worst outcome is a client chases away one of our valued employees. And then there's strategies that when you do have a difficult client, what you do is you have two people in the room with that difficult client, not just one, because clients who are difficult hear things and see things differently, and you are putting somebody at risk when you have a client like that. So I always say to lawyers, have your legal assistant in the room with you when you meet with that difficult client. So there are notes being taken and there's a memory of what really happened in that meeting. Because a lot of times, what I find is people in a law firm are, again, at their worst because something bad has happened. They're distorting information. Our memory only allows us to take in so much information, and we take in pieces of it and then we consolidate it into a memory, and it's inaccurate. And it's not that they're lying or being difficult, but that's how our memories work. So in those high stress situations, having two people present is a mitigation for risk to everyone in the practice.